decided to sit at that table, but he will end the conference at the end of this session. It's very nice to actually be here in person for the first time in 2 to 3 years, and I don't think I've been in company of so many since the pandemic began. If my throat gets a little bit croaky, it's because I was released from self-isolation just yesterday, but I'm okay, honestly. Don't worry, there's a good gap there. It's poor Jenny that's going to get lumbered with it. As you'll see from the screen, I'm Ken Macdonald. I'm head of ICO Regions, which means that I head up or have responsibility for the 3 offices that we have, the one up the road now at Queen Elizabeth House in Edinburgh, the one in Belfast and the one in Cardiff. I couldn't do my job, though, if I didn't have an excellent regional manager. And many of you will remember Maureen Faulkner, who retired at Christmas 2020. And we're very pleased that Jenny got the job and is now regional manager in Edinburgh. We're going to do a very brief introduction to this session, but we are accompanied online by 2 colleagues based in our head office in Wilmslow. There's Michael Murray, who's head of regulatory strategy, and there's Paul Comerford, who's a principal policy advisor, and Jenny will introduce them after our very brief session. We're covering today just a very quick introduction to the ICO and the work of the Scotland office, but the main topics for today are the Children's Code covered by Mike and the anonymisation guidance that Paul is covering. But I just want to say a couple of words about the ICO itself. We're in a period of change. We've been in change for a long time now, particularly just prior to GDPR being implemented in 2018. We started to see a huge increase in staff numbers. And I was actually looking at them the other day, and it's been an 80% increase in organisations since then. A huge growth in the number of staff, but also a growth in the range of activities that we're doing, and particularly, I think, on the technology side and the guidance side. But of course, the biggest change that recent times occurred on the 4th of January this year, when our new commissioner took over. John Edwards joined us. He was previously Privacy Commissioner in New Zealand, and he succeeds Elizabeth Denham, who has now moved on back to Canada. We seem to be collecting people from around about the Commonwealth to take up our key posts. And John was up here in Edinburgh just about a month ago, and it was a real pleasure to meet him. And I hope that many of you will get that opportunity in the years to come. Part of his reason for being in Edinburgh was to meet the team here. He's also done Belfast and Cardiff and met the guys that work out of these offices. But it was also to introduce himself and his listening tour. And he's making it very clear that he's not going to impose any new approaches by the ICO until he's listened and learned from feedback from our stakeholders. And we did have a couple of sessions. Unfortunately, we were quite limited in numbers, but we had a couple of sessions here in Edinburgh with data protection officers from mainly the public sector, but also some private sector and voluntary sector representatives. And I can truthfully say that he was listening. He was asking questions when we were criticised. He was looking for solutions offered by the stakeholders we were speaking to. And there is on our website an opportunity for you all to feed in to this listening tour under our Your Views Matter campaign. There's a short survey. The link is in that on that slide. But if you go to our website, www.ico.org.uk, then you should find quite easily the Your Reviews Matter logo. Click on that, and you'll get to the survey. And we want positive criticism, we want friendly criticism, we want unfriendly criticism if we deserve it. Please, everything there, warts and all. And I know John will take heed of it, and it was shown in the way that he was reacting in his sessions with us in Edinburgh. But I'll pass on now to Jenny. As I say, she's the regional manager now for Scotland and heads up our small team here at Queen Elizabeth House.
Great, thank you, Ken. Thank you for this as well. Yeah, I just wanted to say hi to everyone this afternoon, and thank you very much for coming along, and it's great to meet you all. I wanted to say a few words about the Scotland office and what we do. As Ken mentioned, we're a fairly small team of 5. We've got 2 senior policy officers, 1 lead policy officer, and we've got our advice officer who answers inquiries that come into us by phone and by email. So if you ever get in touch with the Scotland office, it's probably our advice officer, Anne, who will be responding to you in the first instance. And we actually have 2 of our team here in the room today as well, Dominique and Adam. I don't know if you want to give them a wave, and they'll be answering all the really difficult questions that you have for us later. Pass that on to them. So we are a small team, so what we tend to do in the Scotland office is focus on upstream support where we can and improving data protection compliance, and we prioritise looking at issues which are related to new and novel processing or high-risk processing. So please, if you've got any kind of data protection inquiries where you'd welcome regulatory inputs or a view, do get in touch with us. We'd always ask if you have a data protection officer to get in touch with them first and then come to us once you've spoken with them, but we're very happy to help, although bear in mind, of course, that we will prioritise those areas where we can have most impact. I wanted to just highlight a couple of new or relatively new ICO resources which may be of particular interest to those joining us this afternoon. So we've got Michael, who will talk about the age-appropriate design codes, the children's codes, and Paul will speak about anonymisation guidance. But I also just wanted to highlight some other guidance which I think will be particularly useful. We've got our AI and data protection guidance online, and also our data analytics toolkit. So if you're thinking about using AI or data analytics in the work that you're doing, please do take a look at those resources online, and that'll give you, certainly the data analytics toolkit will give you tailored advice there. We've also got our data sharing information hub. So you'll be aware that our data sharing code of practice is now in force, and there's a range of tools and resources on our information hub which will help you share data in compliance with the law. And we realise that as processing becomes more complex, it involves much more data sharing, so there's a whole bunch of kind of resources and templates there which will be helpful, I hope. The other thing to mention that came into force just earlier this month is our international data transfer agreement. So this is what replaces the standard EU standard contractual clauses, and there's an addendum there if you're already using the standard contractual clauses which can convert it. They've been basically put together from scratch. So we've had a blank sheet of paper as the ICO to put them together, and they take into account the Schrems II judgment as well. So hopefully that's useful, and they're designed to be user-friendly. So please do give us your feedback. We'll be adding more kind of guidance and resources into that area of our website, and I believe there will also be a risk assessment tool which will appear there. We suspect around about May, but as ever, these things are a little bit of a movable feast. That is what I wanted to update you on in terms of guidance, and I'll now hand over to Michael Murray, who's our Head of Regulatory Strategy, to talk about the Children's Code.
You mute, Mike.
Apologies. Hello, everybody. Jenny, I can't see the audience, so I'm assuming that the slides are up. Yeah, okay. Well, because I can't see you guys, I'm gonna make an assumption that people in the audience are both data protection professionals and parents, and that many of your children will often be in their room accessing the internet behind a closed door. Sorry, I'm getting some feedback as well at the moment. Can anybody hear that properly?
We can hear you fine.
Can hear it fine. Okay, thank you. Sorry, I'm getting feedback on my end. Okay, well, yeah, so the kids are often at greatest risk when they're at home, behind closed doors, away from parents who often don't know what they're looking at, and perhaps don't know how data is collected online on the internet. So there's often a physical as well as a digital world removed between parents and children these days. What we're trying to do with the ICO is sort of address some of the risks that are associated with children being online. And now trying to move on.
Oh, you've got the mic here.
Yeah, Mike, you're mute again.
Not sure. Sorry, everybody. I'm not sure why that's happening. Okay, I'll start again. So the Children's Code, which is formerly known as Age Appropriate Design Code, is the ICO's main code aimed at securing children's data online. It's designed to shift the main responsibility for keeping kids safe and keeping kids' data safe away from parents and children who often don't know how to do that themselves to the online services themselves. It is, as the formal code says, an age-appropriate design code, a code that's designed with 15 standards to help industry design better child-friendly services. It is based on the United Nations Convention on the Rights of the Child and creates an open, transparent, and safer place for kids to explore and learn online. It's 6 months into its supervision stage for the code. I'm here today to tell you about the code itself and what we're doing to support organizations and schools and parents and children to learn about it and to keep the data safer and to share some lessons learned since the one-year transition period for the code ended in September 2021.
You've gone mute again, Michael. That's the slide changed, but
there seems to be going on mute every time the slides change for some reason. I don't know, it's a technical issues, and apologies for everybody. Apologies for not being able to be there with you in person. So what role does the code play in law? So the code is rooted in existing data protection laws. It was one of 4 codes that the ICO is committed to bring in through the Data Protection Act in 2018. The code is a helpful tool to support organizations meet their data protection requirements as underlined by underlying data protection legislation, such as the UK GDPR and PECA regulations. It's on a statutory footing, which means that our supervision teams and courts of law must take the code into account where relevant. Generally speaking, non-conformance with the code will make it difficult for online services to demonstrate that they're processing children's data fairly and to comply with data protection requirements. Okay. So a couple key definitions about the code. It applies to relevant information society services which are likely to be accessed by children aged under 18 in the UK. And those 2 pink phrases are critical here. So information society services, we've got the definition, any service normally provided for remuneration at a distance by electronic means and at the individual request of the recipient of services. Just to to clarify that when we say remuneration, it does not just services that sell products directly to children or their parents. It is also any service that is supported economically by things like advertising as well. The likely to be accessed by children is there on purpose. It's a break from previous regulations that looked more at targeted services or services directed at children. The UK Parliament recognized the breadth of services, online services that kids use, and wanted to make sure that the code applied to all services that they were likely to access. So that's been one of the issues that we've noticed so far in the code to date, is a bit of a lack of understanding of what that means. So generally likely to be accessed. We're not giving a sort of percentage value because it'll depending on if it's a large social media site or a small game about how many kids are engaging. But basically, if you apply that test of it's more probable than not that children are using the game, then you're likely to be in scope of the code. If you think you're in scope, you probably are. So this slide shows the 15 standards of the code, and they range from data processing standards to more general policy standards and good practice guides. So they're all based on the best interest of the child, the first standard of the code, which is increasingly becoming an internationally recognized standard for children's protection. It's referred to in OECD guidance on the code. It's a critical part of not only of the ICO's Age Appropriate Design Code, but also of the Irish DPC's Fundamentals on Children's Privacy, the Swedish Data Protection Agency and the Dutch Data Protection Agency and the CNIL in France, all also basing their children's guidance on best interest. Basically, what we're looking at is that online services take the best interest of the child as a primary consideration when designing services. And that's a good thing. And it's not as scary as it sounds for online services, because you're balancing the full range of children's rights and interests here. So that would include, for example, the right to play, the right to parental support, but also the right to safety. So when you're considering the design of your service, you're looking at all those rights and considering what's best for the child and what's best to keep them safe and their data safe online. So where does the code fit? Bigger picture is it is complementary but distinct from the new online safety regulations that we've seen released last week. The code focuses on data protection. It is not focused on content, which will be covered largely by the online safety bill. It does apply to services established both inside and outside the UK, as long as those services are targeting children in the UK. So in our supervision process at the moment, we are working with online services that are based in the US, based in France, for example. If that service has, for example, terms of reference, terms of service that mention the EEA or UK, then they will be in scope of the code as serving UK children. We are working closely with other data protection agencies in Europe and the US as well to try to push this narrative of protection for children, and so that we have a sort of a global view of how to keep kids safe online. We recognize that a lot of services will fall within scope. In our economic impact assessment, when the code was laid in Parliament in 2020, the estimate was upwards of 150 to 200,000 online services could potentially be in scope. To be honest, we're not going to be looking at everybody in the same way. We're taking a risk-based and proportionate approach to regulation, focusing on services that are higher risk to children and where the children are most likely to be found. So those are how we're sort of focusing our attention for the next year or so. So why is this important? Well, children have their data being collected from a very early age, sometimes even before they leave the womb. By the time kids are 18, they will receive tens of thousands of targeted adverts, and online services will have collected data on their name, their age, their date of birth, their favorite football team or band, email addresses, for example, where they live, where they go to school. For some kids, data collection will include their health data, their mental health data, their political beliefs, their sexuality, and what their willingness to buy consumer goods. So all of this data can have an enormous impact on children's opportunities, on their reputations, their fairness, their finances, and their relationships. And we know through our research, and a couple examples here, that kids want what they want. They want the services that are important to them. And in some cases, they're willing to lie in order to get access to them. So because the internet wasn't designed with kids in mind, they will basically lie sometimes to get access to the services that they think they need. And we see here about half of kids have admitted to lying to access service. And that number is probably higher for those kids that are 11 to 12 years old, who are just under the 13 age of consent barrier, or kids who are 16, 17, who are just under the age of the adults. Interestingly, about a third of parents also admit to helping their kids log in to sites that are inappropriate for their age. I'm going to go to the next slide. We'll kind of look at that in a bit more detail. We had some research done about parents and children's attitudes to data protection with the Insights family. And one of the questions we did ask parents was about whether or not they allowed their kids access to websites when they're too young, and if so, why. And this slide shows about little less than half of parents said no, they don't allow kids to access services that they're too young for, so less than half. Of those who do, half of them think that their child is mature enough, but these next three blocks show 13% because they wanted the kids to stop pestering them to play that game everybody's playing, or to get access to the social media site to share photos with friends, for example. Or they didn't want their child to miss out on those relationships at school that are fostered through online services, or because they don't have enough time. There's a lot of pressure on parents to be the arbiter about what's right and what's wrong online for kids. And again, the code is designed to try to shift that balance. So parents are supported in making the right decision. Kids are supported in not having to lie about services, ideally, because online services hopefully will be designing in a different way to support children's learning and play online. So again, why is it important? It supports the well-being, development, guardianship, and play. It gives kids autonomy, and especially recognizes that as kids age, they will have more ability to make decisions for themselves, and more ability to recognize risk and what data they want to share and when. It protects children from intrusive profiling, data sharing and tracking, and ensures high privacy by default. If you go back to a couple of those standards, some of the critical ones here would be privacy should be set at high by default for online services. Geolocation and profiling should be set at off by default. So this is shifting responsibility for keeping kids' data safe from parents to children back on to the online services that are servicing children. So we want to talk about what's happening with the supervision of the code at the moment now that 6 months in. The ICO traditionally responds to data breaches and complaints when it's looking for services on how services are conforming with the GDPR. Breaches of the code and complaints will continue to be an important part of how we respond to the code, but we also recognize that children tend not to complain, and parents tend not to complain either. Got a great quote from a focus group that said, "You're not going to complain about your rights, that your rights aren't being upheld if you don't know that they exist." So that helps explain to a degree about why people aren't coming to the ICO about kids' data issues. So because we have that problem, we're taking a more proactive approach on code supervision. So we are focusing on the 3 sectors we believe are the highest risk for kids and where the kids are most likely to be found. So social media, games, and streaming services. And within those, we are started off the process of writing letters to about 49 companies within those services to identify data practices and understand what they're doing to conform with the code. Further action is being taken with about half of those companies as we find issues that are problematic, but other industries will take no further action because they've already done some good things to get themselves ready. We're also offering voluntary audits for organizations who would like to test their conformance and talk to the ICO about what they've already done. In addition, to address some of the more technically difficult issues around age assurance, we've also published a commissioner's opinion on age assurance and are currently involved in some research projects on age assurance as well. So that commissioner's opinion will be updated later this year. And the ICO has certified the age check certification scheme to help organizations with age assurance and the Children's Code certification. So what have we learned so far about the code? Through some research we've done, we have identified that there's a fairly low level of awareness among small and medium-sized, small and micro companies about the code, whereas larger, medium to large size companies generally know about the code. They know where to find the ICO, they know where to find support. So we're trying to focus more of our engagement efforts on that sort of single entrepreneurs, small companies under 10, for example. Some good news is about 40% of the companies have already started making changes to their under 18 business. Sometimes to conform with the code, sometimes just because they knew it was the right thing to do. Although that does recognize that 60% probably need to be doing more, it's at least it's a good start. And that generally has been things like reviewing their policies, their privacy notices, their terms and conditions, and updating their DPIAs. Because a lot of this is being done by smaller business, the impact financially has been lower than we anticipated. Most of that work was often being done in-house or by DPOs. And really nice to see about 2/5 of businesses are aware that conforming with the code is probably good for the business. It increases customer trust and confidence in their service. So to date, from the letters and feedback we've had from industry, we're kind of recognizing some trends that are emerging. First is that sort of lack of awareness by industry of who uses their online services and whether services are in scope. There's still a bit of confusion with some industries saying, well, kids aren't our target market, even though that industry knows that children are playing their game or using the social media services. So we have to go back and remind them that if the child is likely to access your service, you are likely to be in scope of the code. Businesses often don't have a full understanding of what data they're sharing with their partners and other data controllers. So we want to remind them of the data sharing standard and the data minimization standard of the code to get them to review who they're sharing data with and to minimize the amount of children's data that they collect and share. Companies have been a bit slow in updating their DPIAs, and remember, this is a requirement of the code. If you are processing children's data and are in scope of the code, you must have a DPIA that addresses the children's code. And in some cases, we've noted some disappointing age estimation services or some disappointing age assurance practice, whereby some websites aren't even asking anything about age of their users, and there are potential Article 8 breaches of lack of verifiable parental consent for under 13s. We have some ongoing research into age assurance that hopefully will help us identify more efficacious ways for age assurance, and we'll share that with industry in the coming months. There's also an ongoing reliance on profiling by games and social media companies for their non-core services. So what should you be doing then? By now, you should be transitioning into the code, that the transition period is ended, and you should be conforming. Where your site or service is complex and changes to systems or products might need additional time to implement, what we really like to see you be doing is to be able to demonstrate your roadmap towards conformance. Doing things like telling us how you're going to address the greatest risks to children's privacy, how you're going to prioritize development to conform to the code, how and by when you plan to make your relevant changes. So we really think you should first step is know who your users are. Do the research into who is likely to access, what ages they are, user testing, market research, literature that's published by civil society or academics can help you with that. Review your DPIA and map out the children's data processing risks and journeys, and address and mitigate those risks where it's possible. And then develop that transformation plan, as I mentioned, so that we can see what steps you're taking to move towards conformance. There is a whole range of resources on the ICO website to help industry in this process of transformation and conformance. The ICO data protection for organizations website. There's the ICO SME Hub and Innovation Hub, and also an ICO sandbox that you can apply to. The ICO Children's Code Hub has FAQs and guidance. There's templates for DPIAs with some worked examples for online retail, games, and a connected device on there as well. Best interests of the child framework and guidance about how to use it as well. And we have some award-winning UX design guidance to show designers how to design in a way that conforms to the code. Feedback from designers have suggested it's been very well received and very useful. And of course, I mentioned the age assurance opinion as well. So that's a quick run through for the code and where we're at. Please do keep in touch. We are open to engagement, ongoing engagement with the sector, to answer questions and to connect you to our assurance teams if you'd like to take up one of those voluntary audits or to engage with us about the work you're doing if you have any questions. And I'll hand back over to Ken and Jenny now to see if there's any questions from the audience.
Thank you, Michael. I'm getting a little bit of feedback. Are there any questions first from the floor? I know Ken's going to look and see if there are any online questions, so I'll hand over to him in a minute. But has anyone in the room got a burning question for Michael? I'll leave everyone to think about it. Ken, have we got anything from the online chat?
I've got two on the online chat. Excuse me. The first one is from Paul Dick. Would the code cover education apps which are primarily sold to schools for onward use to pupils through school-issued devices which may be used at home?
Okay, well, that's an interesting one. We do have some EdTech FAQs on the Children's Hub website. So, Paul, the first thing to do is take a look at the responses to those FAQs. I think with many regulators in this field will answer it depends, really, and it really depends on what data is being collected and your relationship with the school. Generally speaking, schools themselves don't fall within the scope of the code. If the school is the controller, then their legal basis for processing won't be a consent based. Generally, it's a public task. And so they won't be an information society service, so they don't fall within scope. However, schools would need to comply with the GDPR. EdTech providers it depends on the relationship with the school and what data is being collected and by whom. If the provision is at all directly to children, directly to consumer, then yes, the EdTech service would definitely be in scope. But I think what we need to do is probably look at that on a case-by-case basis to see what data is being collected and what relationship you might have with the school.
Okay, thank you. Again, anyone from the floor? No, they're awfully shy here. Okay. Gavin Jarvie has asked, it's quite a long two-part question. How do you manage to protect a child from online content when some of the more tech-savvy children will simply circumvent most of the controls implemented through use of VPN software? Is there new technology in the pipeline that can prevent a child launching a VPN on their mobile devices to see content that in some cases would be abhorrent to adults, never mind children?
It's a good question. And I'm going to refrain from answering that second one. To be honest with you, I'm not sure about new technology that's in the pipeline. It's a tricky one. Just to confirm, so the children's code itself is a data code, and so it's not primarily focused on content. However, we do know that data processes are important in getting content to kids. Most likely, the tech-savvy child is going to be the one who's going to find ways around anything. But I think one thing that we are trying to encourage online services is to try to apply the code to all users if possible, because it's a good practice guide about how to keep your users safe. So if every user has the benefits of the code, has the benefits of, for example, having their privacy as high by default, their geolocation high by default, and their profiling off by default, then if a child uses a VPN to get around any sort of age gating, then they will still have the benefits of those code protections. And again, what we're saying is that those protections, it's a choice. So if the child decides, no, actually, I'd like to get content recommendations, or I'd like to see adverts that I might be interested in, so I'm choosing to enable profiling, I'm choosing to enable geolocation, or I'm choosing to enable more than just my friends to see what I post online. That's the choice that the child is making. You still have responsibility to help educate the child and have really clear transparency notices and privacy notices so that they know the impact of the decisions that they're making. But if you're designing a service that is going to protect people's data and include some of these core code standards, then that just should help protect even the most tech-savvy child. However, I think in most cases, most children wouldn't be tech-savvy. Most children probably don't have a VPN. And there is where the code is most likely to have its benefits in trying to create a general internet where the majority of kids who just want to go on and play a game or learn or access a film or talk to their friends will be protected. Their data won't be being shared across the internet. These massive profiles being developed about them won't be as massive and won't be as intrusive in the future.
Great. Thank you.
Can I just ask, can you ask Michael, how do they currently detect breaches? If there's a breach of the code, how do they know?
Michael, did you hear that?
Yeah, if there's a breach in the code, how do we know? Well, to start with, if there is we're going to be responding with the code with supervision in three main ways. Again, looking at data breaches. So if a organization reports a data breach to the ICO, and that data breach involves children, then we will be looking to see that the service has applied the code when we're responding to the data breach. If there is a complaint from civil society, from a parent, then we'll look to ensure that the code is being applied as well. and also this sort of proactive approach that we're taking with the highest risk services, writing letters to them, learning what their data processing is, and then acting on the responses that are highest risk. That's generally how we're looking at it. And then essentially, I think if as more and more countries adopt a similar approach, I think companies who operate internationally will be falling within the ICO's remit, the Irish remit, potentially within others as well. So it won't be just us that is looking at conformance, but it could be other data protection agencies as well. And I think we'll hopefully start seeing a lot more internet services recognizing the benefits of the code in developing trust with their clients. So hopefully the breaches will be fewer and farther between, but there always will be, as there's breaches of the GDPR. So we'll be looking at using those three methods to identify them and to take action when we find them.
Okay. Thank you, Michael. I think we will now move on to Paul's presentation. Just a reminder, there will be the opportunity for questions after Paul's presentation, but there's also, if you've got any sort of general burning questions for Ken and I, or indeed Dominic and Adam, our senior and lead policy officer in the audience, you can ask them at the end. So now I'll hand over, if everybody's ready, I'll hand over to Paul Comerford, who's our principal policy advisor, to speak about our anonymisation guidance.
Thank you, Jenny. I will just share my slides one moment. Okay, I hope everyone can see my slides there. Okay, so hello everybody. My name is Paul Comerford. I'm a Principal Technology Advisor at the ICO. I am based at the Wilmslow office, although I live in sunny North Wales. And today I'm going to give a talk about our plans for updating the anonymisation guidance. And I'm one of the leads for that work. Okay, so I'll talk a bit about our guidance plans and what we've done so far, and our future work around anonymisation. I'll talk a little bit about identifiability, and this is something we look at in Chapter 2 in particular of the guidance. The various interpretations of identifiability that exist and our position on that. Our upcoming guidance on pets and some of our wider pets work as well. And then we'll break for questions. So in terms of our anonymisation guidance plans, we've been planning this work now for some time, and we did start this work before the COVID pandemic broke out. Of course, there was a need for replacing the existing guidance, and it was twofold really. Firstly, obviously the introduction of the UK GDPR in 2018, and also technological developments. Of course, the original guidance was published way back in 2012, and of course there's been many technical developments, new breakthroughs in both anonymisation techniques and also flaws and attacks on anonymisation, and the amount of data that's shared has increased exponentially since 2012. So there was a clear need to update our guidance in line with both legislative, if I can say that word, and technical developments. So in that vein, we started planning out what that guidance would look like, and we decided from an early stage that we would release the guidance in chapters rather than a single document. A couple of reasons for this really. One, it allows the various stakeholders to have a look at our thinking at an early stage and provide feedback. It helps us from a management point of view as well. We can get stuff out earlier. So I think that's worked pretty well so far. So in terms of progress, currently we have 4 chapters published. The first was anonymisation in the legal framework. So we looked at the various legal policy issues around anonymisation and pseudonymization, how those intersect with data protection law, and which parts of the UK GDPR and DPA 2018 were applicable. And that came out quite a few months ago now. We've had some really good feedback from that chapter. Following that, we published a chapter on identifiability, which is probably arguably one of the most important chapters within the guidance, because we cover how identifiability should be measured and how it should be assessed, how to manage re-identification risk, and what tests need to be applied to the data to ensure that it's effectively anonymous or not. So we look at things like the reasonably likely test, which I'll talk about in an upcoming slide, the motivated intruder tests, and how they should be applied in practice. So again, this was put out for public consultation, and we've had some really useful feedback, some positive feedback, and some critical feedback as well, which we need to take into consideration. Following that, we published a guidance on pseudonymization, which is also a very important area. There's a lot of confusion around pseudonymization and anonymization. We see that sometimes those terms are used interchangeably. And also, we wanted to clarify misconceptions about the identifiability of pseudonymized data from depending on who has that data, and what means they have to re-identify individuals. For example, do they have the key to re-identify, and so on. And then lastly, we published quite recently guidance on accountability and governance requirements. So looking at areas like data protection by design requirements, DPIAs, and so on. All those accountability requirements that a data controller must have in place. So that was published a few weeks ago. So upcoming chapters, we have anonymisation and research. And this will look at how anonymisation and pseudonymization apply in terms of things like Article 89 exemptions for research for pseudonymized data, best practices around using anonymized data for research and such like. This is currently under internal review, and we're hoping to get this published fairly soon. Following that, we're going to be issuing some preliminary guidance on PETs, privacy enhancing technologies, and looking how PETs intersect with DP law and how they can help with compliance. I'll talk more about those later in the presentation. And then following that, technical solutions. So we will look at best practices for implementation of both anonymization, pseudonymization, and PETs solutions. So, what sort of technologies should data controllers be considering? What we wouldn't expect them to consider, how they should be configured, and so on. So that's hopefully going to be published later in the spring. And finally, we are working on a selection of data sharing case studies. So we will explore various technologies, various sectors, and look at how best practice would be applied, considering the purposes of the processing, and how those technologies work together, and how they comply with data protection law. So we've engaged with a number of stakeholders to identify suitable case studies and develop those. But that we see that as something as an ongoing piece of work and a repository that we will add various case studies in the future as technology develops and so on. Okay, so I'm going to start with one of the most important topics of Chapter 2, which is the spectrum of identifiability. So if we look at the status of personal data, so the identifiability of that data. It exists on a spectrum. Now, in reality, that you could say data is either personal or it's anonymous. So in that regard, it's outside of DP law. But in reality, the data will exist on a spectrum. It could be directly identifiable. So there might be names, addresses, direct identifiers in the data. If that information is removed, it might be still identifiable, but indirectly. So if you combine different attributes within the data, there's still potential to identify somebody. That's where things, as we move from left to right on the spectrum, things start getting a bit more difficult. And we're talking about data now that it's quite difficult to identify somebody. So we need a test to consider what factors we need to consider to determine whether it's anonymous or not. And this test needs to be done both from the perspective of the controller and any recipient of the data, because the means that they have to re-identify might be different in different cases. So if we look at the UK GDPR recital 26, we've got something called the reasonably likely test, and that lists some of the factors that a controller or another party may want to consider as part of their assessment. So things like the cost, for example, that it would take to re-identify somebody, the monetary cost, the computational power, the technology available to do that, the time it would take. So some techniques, it might not be computationally feasible to re-identify somebody. Also, depending on the environment, if it's in a closed environment, what controls around that data, what's the purposes for processing, do the purposes require you to identify someone as part of the processing? That makes the decision easier to determine if it's identifiable or not. So you've got the means to be used, and you've also got who would likely to want to access that data. And this test is called the motivated intruder test. So we would consider someone that was suitably motivated, had a reasonable level of competence. That might differ depending on the value of the data, how long they would take, how much it would cost, and also any legal gateways that might be available for an individual to access that data. Do any of these legal gateways exist? And this is not an exhaustive list, but it gives some of the main factors that a controller or a processor needs to consider. And from that, you would deem whether it was likely or reasonably unlikely, or likely or unlikely that that information is either personal data or it's effectively anonymized. In other words, there is no way that somebody could either single out somebody from that data. They could infer with a good confidence that an individual was in that data, or they could link the data they have with something else that might be in the public domain, or it might be another data set to re-identify somebody. Now, as you get further to the right, you get to data that's highly aggregated, and it's basically, even if it was released publicly, there would just be no way that you could identify anybody from it. In the current guidance, we call that truly anonymous data, but it's basically data that's will be anonymous for any party, basically, whether it be the controller or any other person in the world, simply because it just doesn't have any individual level detail in it, or does not relate to any individual. So if it's anonymous, data protection law does not apply. Obviously, you have to keep things under review. What is anonymous now might not be anonymous in 5 years' time. Technology develops, the amount of data sets around develops. So this is something that organizations need to keep under review. It's not something that you can release and forget, unless, of course, you are releasing to the public. Of course, then it has to be a lot stronger measures, because once that data is released to the public, you can't take that back. So that's the spectrum of identifiability. That is one of the key points around Chapter 2. Now, there are various interpretations of identifiability. The ICO promotes the relative approach, and this is something that we've done with the previous 2012 guidance as well, where we're looking at re-identification risk from a relative approach. So we're looking at who has that data and what are the re-identification risks for that organization. Okay, so there is a possibility that data could be personal data, for example, from the controller's perspective, but in certain circumstances it might be anonymous in another party's hands if they perform that test for re-identification and they deem that there's no means reasonably likely for identification. So basically, this is a risk assessment. It considers not only the techniques applied to that data, but also environmental controls, who has access to that data, and other factors as well. So this is an approach that we've had for some time, and that doesn't really change. It's also the same approach that's taken by some EU DPAs. A more strict approach is the absolute approach, so where re-identification risk is effectively zero, and data cannot be anonymous if the original personal data exists somewhere. So, for example, the controller has some personal data, they produce an anonymized version of that where no one can be identified, they share it with someone else, and with the absolute approach, even if the other party had no means to re-identify, it's still personal data. It's much more restrictive because effectively it narrows down the amount of data that you can share in some circumstances. So this generally doesn't consider environmental controls, it just considers the actual data itself and whether that data is identifiable or not. So this sort of approach is championed in Article 29 opinion anonymisation. Keneal mainly wrote that, and although the EDPB have not endorsed that opinion, looking at subsequent publications, that they do reference it. So EDPB haven't released an update to that, but I've heard they're working on it at the moment. Okay, so privacy enhancing technologies. So this is a big area for the ICO, and we're doing a lot of work in this space. And one of the chapters in the guidance will be dedicated to PET. So some of the PETs that we're looking at, homomorphic encryption. This is a type of encryption that allows you to do computations on encrypted data without decrypting that data. So this could be useful, for example, in a cloud environment where a client wants to perform some computations, but they don't want anyone within that environment or an attacker to access that data. So it stays encrypted, and the cloud provider, for example, cannot access that data. Problem with homomorphic encryption, it's got some issues with scaling at the moment, and it's limited in the amount of computations it can do. So real-time computations is a little bit limited, but things are improving all the time in that space. Differential privacy, this suite of this sort of encompasses a suite of techniques that look at adding noise to data so that no individual could be singled out from that data. And this is useful for things like releasing aggregate statistics. There are different types of differential privacy as well. You can add noise on each individual's input to the data. And this is useful for things like, for example, IoT devices contributing data because it can hide the attributes of that individual. It's a really useful technique. We're seeing more use of it now, but I would say it does dilute utility quite a lot. So it provides a guaranteed level of privacy, which is defined by something called a privacy budget. I won't go too much into the detail, but suffice to say, it provides a strong level of privacy, but it can dilute utility quite considerably. But again, it's a useful technique for things like statistical data to ensure anonymity. Secure multi-party computation is another useful technique. This is useful where you've got a number of parties that wish to share data with each other. Due to data minimization requirements, they might not be able to pool their data into one data set. So they just want to see what data they have in common with each other. And it uses some fancy cryptography, such as secret sharing, to do that. So that provides data minimization, data security, and allows various organizations to gain insights on the data they have. And we've seen this used for a number of pilot schemes. Things like the FCA have done some tech sprints utilizing these techniques to detect financial crime, for example. But again, like homomorphic encryption, this is an area that is still growing, and there's still scalability issues that we're seeing before these sort of techniques become mainstream. Trusted execution environments is another useful technique. It's basically a part of your processor, for example, on a mobile phone, that isolates code from the operating system and other apps running on that device. And it's like an extra layer of security. It does have its limitations, and there are some vulnerabilities, but this can be a useful technique combined with some of the others. And federated learning, a useful technique that allows decentralized training on a machine learning models, for example, using things like mobile devices. So that the model is trained on the device, and then updates are sent to a centralized server. And this is really good from a security point of view, because the data is not held all in one place. It's basically decentralized. But again, to get better protection and privacy for federated learning, sometimes you need to consider combining some of these other pets with it to provide the protection it needs. So that's just a flavour of some of the pets that we're looking at. And of course, these can be applied on their own, or they can also be applied in combination with each other, depending on the purposes of the processing and the types of techniques that are being used. So some of the questions that we're looking at to explore in the PETS guidance: what are PETS? What does DP law say about them? How can they help comply with DP law? Where do they fall down? What do we consider state of the art in terms of PETS? When should you consider using them? And how can they help achieve data protection by design, for example? And in that regard, we see PETS as a promising suite of techniques to ensure compliance. They're not a silver bullet, but they will help in some cases. Things like data minimization. They can reduce the amount of personal data you need to process, and data can stay on device in some cases, and it's not shared centrally for some technologies. It can improve security because less people can access that data due to the cryptographic properties that are in place. It can help anonymize data in some circumstances, things like differential privacy, and it can help you take a DP by design, a default approach to your processing, which of course is a legal requirement of UK GDPR. So some of the other things we're going to look at is how to implement them, what the best practices for implementation, what should consider about feasibility of these techniques, security risks, and best practices to mitigate those. We're going to talk a bit about how PETS fit on the spectrum of identifiability, because this is a commonly asked question, whether PETS are processing personal data or do they anonymize the data. And And lastly, as part of our wider pets work, you may or may not be aware of this, but we've recently awarded a pot of money by BEIS and the Better, I've forgotten the name of the actual Better Regulations Institute or something like that. And basically, this is a project called Privacy Enhancing Technologies for Public Good. So we were awarded of a grant, £187,000. And as part of this work, we developed a series of workshops which looked at the application of pets in the health sector and some of the barriers, not so much data protection, but some of the barriers to adoption and how we could address those barriers with future work. So we held 3 workshops that were really well received, and we're just in the process of writing up the reports on that. So hopefully they will be available shortly. I can't give you the exact date on that publication, but they should be available shortly. Okay, so we've had some really good feedback so far from the anonymisation guidance, particularly the first couple of chapters. We do have an inbox. It's called anonymisation@ico.org.uk, and we would welcome your feedback if you haven't had the opportunity to read the guidance so far yet. You'll find that on our website, and all feedback really welcome, and happy to take questions. Thank you very much.
Thank you, Paul. Are there any questions for Paul from the floor? Oh, we've got one over here.
Thank you. Just had a question about the interaction of anonymisation with kind of international transfer rules. If we're looking at it relatively and the control that it's personal to them, but it might be anonymous in the hands of the person it's going to in a third country, is that seen as a transfer of personal data or not? Because yeah.
Yeah. It's a difficult one. We've had some conversations with other DPAs like CNIL, and although their definition is quite strict around the absolute approach, there hasn't really been any proper guidance from a lot of these DPAs since GDPR. Obviously, pseudonymized data is an appropriate safeguard for, if it's done properly for transferring data. And the EDPB recognises the use of pseudonymization of pets as appropriate safeguards. Whether it's anonymous or not, I guess you would have to look at the data, the jurisdiction that it was going to, and their approach, and look at, would they consider it anonymous or not? I can't give a definitive answer on that because we haven't really gone into that too much in the guidance so far. But it's something we probably will explore. But that's all I can say on that, really.
Thank you.
Thank you. Anyone else on the floor got a question? Okay, Ken, have we got any questions online?
We've got another from Gavin Jarvie. There are some opportunities for quick wins in the application of pseudo-anonymisation of data to protect public figures, politicians, company directors and secretaries. Trademarks, patents or some other potential areas for this policy being applied to. Are there any plans to introduce that in these areas, and is there any sort of timeline around that, if so?
Apart from the existing chapter on pseudonymization, there are no plans for looking at those particular areas. I guess that's something that we could, if those areas would make good case studies, which sounds like they would, then we would be happy to receive proposals for case studies. on those particular data sharing scenarios. So I guess it's not something we're looking at specifically, but if there are people in the audience that want to, for example, email the anonymisation inbox with potential case studies that are relevant, pseudonymisation case studies, then we'd be happy to look at that.
Okay.
Any further questions?
Sorry, I've got one actually for Michael from Jens Rasmussen. One of the more obvious examples of trying to comply is YouTube segregating content as intended for young audiences or not. But decision comes down to individual content creators, and of course only applies if the children are using YouTube's kids version. In reality, some compliance, but relatively little difference in actual usage, I suspect. I mean, that's more of a statement rather than a question, but do you have any comment on it, Mike?
Thanks, Ken. Yeah, I think our stats show most kids are actually using the full-fat version of YouTube even before they're 13 years of age, and are allowed to within the YouTube's terms and conditions. So there's clearly issues there around how YouTube polices its terms and conditions and its age assurance measures. There's a couple of things there. I think YouTube has its own responsibilities around content through its community standards. The code is not meant to be the ICO policing content. That's not what it's about. The Online Safety Bill or the current VSP, YouTube is, I believe, Google is in the VSP, one of the organizations covered by it, would cover that type of issue. But we're more concerned with the data processing that's happening behind the scenes that allow kids to access content. The profiling that might be happening on YouTube, or the age assurance, or what sort of data is being collected on them. So if the individual producer of the video that's on YouTube is making that available on their own website, then yes, they would fall within scope of the code. But YouTube itself would fall within scope. And we'd be looking to YouTube to see how they process children's data to allow them access.
Thank you.
I hope that answers the question as I understood it.
I think it did, yes. Thanks.
Okay.
Do we have any other online questions?
No.
No. Anyone on the floor got either a question for Paul or for Michael, or indeed just any burning data protection question that you've always been waiting to ask? We've got one here.
Oh, beg your pardon, sorry.
Thanks, yeah. Just a kind of thought, and maybe it relates to the question earlier, but the concept of consent has come up quite a lot today, and when I hear discussions from you guys from the ICO, there's a lot of differentiation between identifiable data and anonymised data, which is perfectly understandable. What I'm thinking, though, is that regardless of whether the data is identifiable or anonymised, there is still a monetary value, and it still can be monetised. Yeah. So even if once the data is anonymised, as a consumer, as the person who provided that data, does the legislation have anything covering protection? So did I might have consented to my data being used in a certain way, but once it's anonymised, how do you know whether I've consented it to be used in that way, which someone somewhere is still getting monetary value or insight out of it that I may or may not approve of, whether socially or I don't want that company to make money, or I don't want that country to be able to make decisions based on data that has ultimately come from me. And I know not all anonymised data is going to be ultimately, even if you can't actually trace it back to a person, it's not even going to have derived from an individual, but a lot of it will be. So is there any of the legislation that covers that?
Okay, it's a really good question. Paul, do you want to answer?
Yeah, sure. Yeah, I mean, the process of anonymisation is still processing of personal data. So, a data controller still needs to fulfil their obligations around that, and they have to have a lawful basis. It has to be lawful, fair, and so on. They would need to either get consent or have some other legal basis for performing the anonymisation in the first place. And if an individual didn't want their information to be anonymised for further use, then that they'd have the right to object to that. I hope that answers your question.
Okay. Mark, did you have a question? Oh, we've got one other.
Hello Jenny, I'm Michelle. I work in healthcare and I've met you on the IG Leads forum, so
Hi,
I don't know
Michelle.
if you know me at all or not. So one issue that we're having in health boards and across GP practices is solicitor-made SARS. Obviously they do have the right with the patient's consent to obtain their health data, but we're finding quite often that they're not considering purpose and they're asking for excessive data, and it kind of puts us as data controllers in this a very uncomfortable position of I have to fulfil the patient's right of access, but I don't think the solicitors are working to the GDPR, and they're obviously basing their legal basis on consent, but it's almost a condition of service, because we've had anecdotal reports that when we've said, look, do you know it's the full record that they're obtaining, they were like, well, I didn't know that, but you'll have to give it because they won't represent me unless they get the full file. So I'm just wondering if there's guidance there at all. I could go back to the solicitor and say, this isn't right.
Yeah, I mean, we do say, I think, in our guidance, and it sounds like you're doing that anyway, that you can, if you've got a concern that, if someone's acting on someone else's behalf and accessing their right of access on their behalf, and you're concerned that actually what is being requested may not be what that individual is aware of and wouldn't be comfortable with sharing, if it is a request for the entire medical record and you think, actually, this feels a little bit excessive, then our guidance would be to go back and speak to that individual. I mean, what you're suggesting, it sounds like a sort of another issue, which is perhaps not a SAR issue, but the fact that the solicitor sort of saying, to be able to provide this service, I need all of this data, and that sounds excessive. And then I guess the question would be does the solicitor have the lawful basis to process that data? But it's difficult for you because you're a controller and you've got to hand over and you've got to provide a response to SAR. I would say take a look at our detailed SAR guidance, but it does cover those circumstances where you're feeling that actually you're providing a little bit more data really than the individual might be aware of.
This is actually just a question for Paul. I suspect when you were talking about reviewing PETs and how they might actually apply to various indices, maybe I picked this up wrong. Does that constitute a recommendation by ICO for particular products, or are you just saying this is the type of product you're using? It's a sort of shaper thing. If I try and contact you and say, I'm looking for something to do blah, you can't really answer that question, can you?
I don't think we're going to be saying you should use this technology to do this thing. It's more, these are the technologies, these are what they'd be best used for, and how do they intersect with DP law? We're not going to say, you must use differential privacy for this. It's what you should consider. What would be, the most useful set of techniques for a particular use case, for example. Obviously, there's going to be no one-size-fits-all approach, but, some techniques might be suited for some quite common types of processing. So I think that's what we're looking to address in the guidance.
Okay, right. Any more?
Anything online? No?
No? I'm going to leave it at that. Can I ask you to think, you obviously want to think, but ask you to thank our four contributors this afternoon, Ken and Jenny, Michael and Paul, one more time, please. Thank you very much.